Adjournment request, if any, from item number 1 to 7. From item number 8 to 19.
In item number 4, Lordship, on 17, Lordship, we have filed our affidavit, Lordship. That may be called for your Lordship. In item number 4, your Lordship. On behalf of Union of India, your Lordship. Lordship, in item number 3, it has already been filed. A similar affidavit has been filed in item number 4 also. That may be called for, Lordship. Much appreciated.
May I please, your Lordship? I beg to mention for item number 10, Lordship, require instruction yet to receive, Lordship. So, matter may be possible for 2 weeks, Lordship.
Lordship, in this case, I am appealing for the petitioner, Lordship. There is an interim order, Lordship. Till today, that may be extended, Lordship.
If you.
Twenty-two, 2025. 202. 30th of February.
If you.
May it please your Lordship. Lordship, I beg to mention listing of an eye on Friday, Lordship, in the pending retail, Lordship. I'm sorry, I'm sorry.
May I please, your Lordship, item number 13, adjourned for the day, Lordship. Item number 13, 1-3. Adjourned for the day.
Adjournment request from item number 20 to 30.
May I please your Lordship, regarding item number 28, Lordship, I am appearing for the state government, Lordship. I am praying for a little accommodation today, Lord. I have taken consent, Lordship. I have taken. Other side, but I have taken consent, Lordship. May I pray, Lordship, my name may be reflected, otherwise H. Sharma, Lord. If
Month of June.
for the Lordship. দিলি তো নামটো দিলে তো নালাগে
Lordship, may I please, item 22, Lordship. Lordship, in this time, I am waiting for instruction because probably the case will hit by the litigation policy, Lordship. The appeal may be hit by the litigation policy where the Lordship, I have written to the authority. I have not received the written instruction. Lordship. May after 2 weeks. Lord. Lordship. That's it.
Well, item number 23, 25, my lord. My lord, the Supreme Court matter is still pending, my lord. That has not been filed, my lord.
After disposal of this matter, this matter is.
Yes, my lord. I met.
Yes. As and when it is.
Yes.
March.
Obliged.
Thank you.
My lord, in item number 30, we circulated a note for adjournment. The reason being, my lord, in this case, my lord, no, very well. My lord, but it has to be after the financial year, in the month of April, because we are expecting resolution of the. Very well, very well.
Item number
30.
This is your Lordship. I beg to mention item number 21, Lordship. 21, Lordship. I'm seeking for some obliged, Lord.
Any other request?
May it please your Lordship. Lordship, I beg to mention for listing of an eye on Friday, Lordship, in a pending retail, Lordship. There is some urgency. Lordship. Urgency is that, Lordship, the dispute is between two sets of promotees and direct request, Lordship. Admittedly, I am senior to both the sides, Lordship, but my promotion has been withdrawn, which was granted, has been withdrawn by the government due to pendency of the retail bill. But there is no such order in the retail bill that promotes. I'm going to return on 31st, Lordship.
Monday.
Lordship, then on 26th, Lordship. Lordship, my senior will appear, he will be available on 26th, either Friday or Blessed Lordship.
Daily list for orders item 1 and 2.
Lordship, in this case also, the value of the appeal is below 2 crores. I've written to the authority to obtain instruction, Lordship. And
I am appearing for item number 2 in item number 1, my lord.
no, Lordship, may I allow some time because Lordship. No, Lordship, actually the matter is very old matter. They have written to the Calcutta office. Lordship, may take up to a week, Lordship. In the meantime, Lordship. Much.
Central government, take the central.
Item 3 and 4.
My lord, the affidavit which has been filed by the government of India, my lord, they have not covered the aspect which we are confronted with. They have basically said about the wisdom of the legislature and the executive to make act in the rules. We are not questioning that. The only question is, my lord, yes. No, my lord, yes, that is purport of the affidavit, absolutely correct. Yeah, correct. Uh, Yes.
Lordship. No, Lordship, here we have explained, Lordship, that is, Lordship, it is normally assumed, it is assumed that the person who is driving the vehicle will be the registered owner. Now, if the registered owner was not driving the vehicle, Lordship, we can always make up a Lordship objection to that. Yeah. Yes. Lordship. Lordship. Yes, Lordship. Lordship.
Clarity.
I am appearing in fifth, item number 5, 4. My lord, your lordship will see 167(8)(10). Rule 167.
No, I think for the present court is concerned with the interim relief.
Yes, interim relief only. I am on interim relief. So we have to go and prove our innocence before the police. My lord.
Lordship.
There are many things, my lord, which. And my lord, My lord, kindly cease. I'm sorry.
You're referring to 167 Act or
Rules, right?
rule?
Rules, meeting. Rules are anything.
এখন Act এখন নাই দেখি।
Yes, yes. I will request. It is 167. And then
On page,
827.
in case of it was not.
Page 77.
Proving
We make
innocence
clear
for the
innocence.
police.
Oh,
Sir, sir.
আমি আছি
Only on
জানে,
interim.
আমাদের
I'm also on
PUC,
interim.
PUC
I'm also on that. Now I'm on whole thing.
এটা তো দিছে মানে রেজিস্ট্রেশনটো দিছে
ঠিক আছে। More than that thing.
আৰু ৰেজিষ্ট্ৰেশ্যন আৰু হেৰিটো বাহিৰে বেলেগ একো নাই।
না আমি এজে ভুল কৰিছো কিন্তু আজি পাৰপাস আছিল টু কনসিডাৰ কাউন্টিং
Interim there we have to.
Paragraph 22 আমি করছি।
You have said you have to go to the police.
और एक बात है स्टेट का जो एफिडेविट है स्टेट का एफिडेविट जैसे that you see मतलब लोगों को ये करो that was in a different context central government version is not
That is central government really the power. Execution is on them.
one of the विषय is how can when there is a rule field is covered by rules से कैसे ये करो by executive
तो वो एक ऐसा बुतारो दिखाई कि ना वो इसको फिर कोई बात नहीं। I just show two rules and then.
ये exercise to undertake why नहीं that you have already penalized
Yes. It is decision about.
in fact mood driver हो गया सर से वाले वाले
भाई तो पैसा देंगे भाई वो बोले इसका मिला लो वो वेटर
तो ये तो का दीजिए
अरे नो डिटेल बता देना चाहिए इस फर्स्ट में then he says taking order will consider that he provided what will be photo price कोई copy this could not do that no no तो लगा क्या थी कराना चाहिए no
ठीक है आपने कोई लखमा है
Lordship. If I may read it well, 7. I'm reading 7. If a challan is due
which one you are reading
Beyond the time prescribed.
beyond the time prescribed, specified in sub rule 5, except in case of offences instituted for prosecution by a court, then applications with respect to the license of offender
Okay.
or
License of offender is okay.
Hmm.
If the license of offender has not deposited the challan or the amount of the challan, you can very well within your rights not to proceed with that registration, either renewal or new application or whatever the
Yes.
license, it's okay.
license of the offender
Who is offended?
or
registration of the
motor or
as the case may be.
no,
The person who is the owner, he is not the offender. Despite that, his registration is withheld by.
My lord, kindly
let us
see
read it.
167(1). There is contradictions. I'll just point out 167(1). Any police officer in uniform or any other officer authorized by the state in this behalf shall issue a challan through system of each or e-challan facility, physical or electronic form, to a person acting in violation of the provision of the act. So it is to the person
Person,
who is driving.
offender.
Now kindly see now 167A. 167 capital A, this is 17th Amendment. Challan under subsection 1 and 2 shall be issued in the name of registered owner. This is because they don't want to go and investigate. And my lord, they are no one, my lord, to hold the offender guilty. They cannot hold guilty. It is the duty of the court. It falls within the jurisdiction of the court. I'll just place a recent judgment, my lord, that bulldozer case from Uttar Pradesh. I'll place it before a lot.
But even though suppose a situation where every evidence is there, photograph is there, video is there, it's okay. We are, but otherwise, so how this person can be the owner of the vehicle? He can be.
Yes. And my lord, it comes so and so accused in the challan.
Every offender.
Yes.
He has to pay the fines. He has to do everything.
Even section 177, my lord, and the violation 183, it is the responsibility of the person who has violated, not the owner. And everybody, every one of us, at least this side, we got notices and we have paid. Because who will quarrel with them?
Chaudhary, we like to clarify this situation. We have to read the
Lordship,
matter.
yes, I would like to clarify. I would just like to point out, Lordship, one thing which I have also stated in my affidavit, Lordship. We have framed the rules. There is one part, execution is by the state, that is by the state. That is another part. And on top of that, Lordship, if I may draw your Lordship's attention, there's a road safety, Lordship, committee, which is monitoring the road safety aspect of the matter. And the Supreme Court, I'll just give a copy of this.
2024 judgment.
Yes, I'll just give a copy.
Supreme Court has asked you to frame the rules, but the Supreme
No,
Court
now-
has directed that you frame the rules.
My lord, that is for implementation of section
Person who is not
136A.
offended is Guilty. This can't.
It's, no, Lordship, if I may just take your Lordship to page 9 of that order,
Page 9.
of that order, Lordship.
Will you give me that, your notification? Your notification.
No, no, it's-
Supreme Court order को कैसे भाई?
Paragraph 6, Lordship.
Supreme Court order
Yeah.
follow. Supreme Court, yeah. Which case? Rajsekharan?
Yes, yes.
Rajsekharan paragraph?
Paragraph 6.
All challans issued.
Yeah,
This.
yes. Our attention is invited to a concept paper prepared on the modalities of implementation of nationwide rollout of effective e-enforcement under section 136A of 1988 Act. If at all, we wait till all the recommendations made in the concept paper are implemented by provisions of section 136A of the 1988 Act and rule 167A. 167A is also under challenge here. Of the 1989 rules will not be implemented for few more years. For a period of 3 years or more, the provision of section 136A has remained only on paper. We therefore direct that the governments of all the union territories as well as the state shall immediately take steps to implement the provisions of section 136A of the 1988 Act in terms of Rule 167A of the 1989 rules, which we have quoted above. After making the choice of electronic equipments devices to be used for enforcement of challans. Now, when the authority is issuing a challan, Lordship, now that has to be supported by some other particulars as well. It is not simply the challan.
So, yes, what is your submission then?
Now, Lordship, if
In this case, the validity was not there. They have simply said
No.
they implement the section.
136A, it is for electronic
Lordship,
monitoring.
that is correct, Lordship. Now, on the face of an order directing the states to implement it, whether your Lordship will now,
We can. If there is a, this clearly it affects the right of a person who is not at all the offender. Certainly this. You like to clarify the situation?
Lordship, I would like to file an additional affidavit.
Okay, how many affidavits? Your Lordship, kindly hear our prayer, for it.
Here, it's not a matter, it's a wide, if any order passed by this court.
Well, if your Lordship just give me a second, I'll just say what is there. Right? They've already filed the affidavit. It covers all the points. My lord, kindly have paragraph 9. Our affidavit has, I think in
think so, that
serial number
almost say,
on my lord. So, but I don't know the paragraphs. In my lord, I have written paragraph 9,
which contention,
their affidavit.
their affidavit, which contention of yours is dealt by them?
My lord, they, in the same affidavit, I'm told. If the affidavit has come, then I'll see, my lord.
It is there.
My lord, kindly see first. I'll take your lordships to paragraph 20 of my writ petition. Writ petition, my lord, is paragraph 20.
Paragraph 20 deals with
My lord,
177.
my lord, kindly see. It is
24.
at page 24, my lord. That it is humbly submitted. Composition का निकाल दिखाने के लिए भेजवा दो कोर्ट को. It is humbly submitted that section 177, 179 and 183 provides for imposition of fine, which may extend to so and so as the case may be. The police mentions the maximum amount of fine in the challan and make full efforts with the help of impugned rules and SOP to realize and recover the same from owner of the vehicles without adjudication or order from the court. The specific averment I have made. Kindly see the reply at page 99. Page 99.
Para,
Para 9. Para 9. With regard to paragraph 20 of the PIL, the deponent begs to state that section 200 of the MV Act empowers the state government to compound the offense either before or after institution of the prosecution for such amount as may be notified by the state government. Further, section 200 provides that in case of compounding of offense, if the person is in custody, he shall be discharged and no further proceeding. Then they quote 200, which has nothing to do with the point that I have raised. That's all. Now, compounding of an offense,
Here for that.
but compounding of the offense has to be mutual. If the offender goes and says, I want to compound, then there's no issue. Then everything comes to an end. But they cannot say, since we have power of composition or compounding an offense, we can impose fine on you. And my lord, for a second, my lord, I'll just take your lordship through the latest decision, which is I have given to your lordship.
So we'll consider for this interim play. We'll fix another date. We'll consider. But because it requires some deliberation.
Kindly, my lord, I will abide by what. But your lordship,
We can pass an order.
no, your lordship may not. But if I say it will remain in your lordship's this thing. I just want to give this. I've given my lord. This is this was in my lord that famous bulldozer case where an FIR will be lost, name of accused will be mentioned. Police will go and demolish their houses.
Without even ascertaining who.
Nothing. And there what is mentioned will cover our case one line. If my lord will kindly come to paragraph 71. I've given only relevant, my lord.
Yes.
71. As discussed herein above, the rule of law, the right of citizen guaranteed under the Constitution, and the principles of natural justice would be essential requirement. If a citizen's house is demolished merely because he is an accused, or even for that matter, a convict, that too without following due process as prescribed by law, in our considered view, it will be totally unconstitutional for more than one reason. Firstly, the executive cannot declare a person guilty, as this process is fundamental aspect of the judicial review. Only on the basis of accusation, if executive demolishes the property or properties of such accused persons without following due process of law, it would strike the basic principles of rule of law, and it's not permissible. And this is what they are doing. The moment they issue challan, they hold me guilty, as if I'm guilty and my guilt is proved. And when we challenge, they come and say we have power to composition. For composition, is it
They're
compounding?
compelling you to either come, otherwise we'll take action. We understand.
Well, and it's being, owners are being forced to pay because their pollution under control certificate will not be renewed, that their license will not be
Even
renewed.
after 2 years. Even after 2 years.
Yes, your lordship,
Okay, in the year 2022, you committed this, and even after 2 years.
my lord, Mr. Chief Justice, you told us one story of Rajasthan that a person goes for renewal and he is told there is a challan pending.
My son even.
My lord.
He was stopped and he said, there is a challan pending
Yes,
against
yes.
you. Where in the year 2023,
Why?
nobody knows who was driving on that
Why?
day, the car, and he has to pay.
Yes.
Yeah.
My lord, only we are, at present, we are on the interim
We
district.
are
And so far as our case is
We are
concerned,
listing only, we are granting few days of time and we are listing it in admission. On that day, if it is appropriate, we'll pass.
Your
it.
lordship will mention the interim order will be considered.
Yes, sure. Response to the petitions have been filed on behalf of the Union of India.
Oh, yeah, we can anticipate nahi karte ho. Something to about do that.
These petitions for admission. Yes, Mr. How much time would you like to?
Lordship, that is 2 weeks. then, Lordship.
Please. 1 week plus.
Take?
7, my lord. 7.
I think he has to. Let me see.
Let it be on 7th or 8th.
7th,
Let it be 7.
list on 7th of April. For admission. The interim prayer, the prayer for interim leave shall also be considered on that.
Abla.
Seek clarification.
Yes.
whatever you want.
Item number 5.
Yes.
I'm sorry, my lord, we could not appear before the Lazima court, my lord. There was a direction to provide, my lord, present address of the petitioner.
Yeah.
Writ petitioner, my lord, respondent, my lord. My lord, we have, my lord, inserted the address of the respondent, writ petitioner, from the writ petition, my lord. There are no other address we have.
That was there, you have to furnish a fresh address, otherwise, if you.
My lord, we
Serve them.
we could not trace out any address.
That is your headache, sir.
My lord, some more time may kindly be.
Last opportunity, otherwise this appeal would be dismissed without reference to the court.
Then, my lord, we will, my lord, publish in the
Whatever
newspaper.
it may be, move the
Newspaper,
appropriate application for.
One chance may kindly be given to find out
Last
the present
opportunity is
address.
granted to the counsel for the appellant to take steps for service of notice upon the respondent number one through registered AD as well as trustee. Requisites be filed within a period of 1 week. On furnishing the same, let notice be issued to the respondent number one returnable 3 weeks thereafter.
Lovely. My lord, instead of. My lord, instead of in.
Yes,
My lord, may I pray 2 weeks instead of 1 week, my lord? We have to find out.
okay, 2 weeks and then further 4 weeks.
Obliged.
Item 6.
May it please allow.
This intra-court appeal has not yet been registered because there is a delay.
Last occasion. We have, on the last occasion, we had clarified
Yes,
and I think so, you appeared. And we already asked you, delay is condoned, now argue on merits. Then you took MK, my senior.
yes, but then
And
order,
we reminded him that
well,
prepare the matter for arguing merits.
I have been conveyed that. But the record says otherwise, that is why I am pointing out. There is no order so far condonation is concerned, but otherwise this court, it is the prerogative, can hear the entire thing. I don't oppose to it.
The matter comes upon for consideration of the IA number so and so with a prayer to condone the delay of 12 days or how many days?
21 days.
21 days. Full stop. There is no serious opposition on the part of the respondents.
Yes.
Hence, part of the respondents, having gone through the content of the application, we deem it appropriate to condone the delay of 21 days in filing the current appeal. The IA is allowed, the delay of 21 days is condoned. With the consent of the parties, the matter is heard finally. Now.
Yes. Now it is regularized, definitely.
Otherwise also we.
And-
Then only.
I am otherwise interested to get it finished because time is constraint for me.
That's right.
Here is a case, my lord. I definitely want that this has already been delayed too long, too long. Now, only almost say 6 months is left. In November, the settlement period will come to an end. So only these days are there for me. I have been litigating right from the beginning. 7 years
That's why
gone.
only why you ask your right, why to waste this time here to think something else.
Well,
Only 6 months is there from last almost 6.5 years. He is running the.
Yes.
operating the fishery.
true. But then my concern is, my lord,
Yes.
because this being the court of records,
the records must be set up right. If there is something wrong, I feel it. My duty is to place it before this forum. The question is, when the bid was initially found to be invalid by the primary authority, the settling authority. Subsequently, certain documents have been recovered or discovered rather from another file pertaining to the deficiencies which were pointed out by the settling authority, that the respondent number 7's bid is invalid because of not containing two vital documents, and declared me only the valid bidder. For the timing, Lordship will just forget the bid amounts, because I am on the legality. The dose issue regarding the bid amount will come when there is a valid bid. Therefore, primary authority found that the bid of respondent number 7 is invalid because it didn't contain two vital documents, namely the Bakija certificate and the experience certificate. And of all the tenderers, my bid was found to be valid, and then it was sent for approval to the government. In Dispur, what happened? They found that these documents, one document Bakija, this is mixed up with another file of another tenderer. And so this is there. And they found that the other certificate can be considered to be a valid one, that experience certificate. And I'll take your Lordship to the relevant findings also, but I'm giving the facts. And then they said that this is valid, and to the contrary, my bid has been found invalid. They say ultimately that my bid is invalid because
Learned single judge said that they can't do.
sorry,
Learned single judge interfered with it.
landed single judge has
Has interfered with.
interfered. Is single
and
judge
he
has
said
said
that, there
that-
was no scope for looking into your documents or
Yes.
bid, and therefore that part
Yes.
is illegal.
that part is settled. That part is settled. Now the question remains only whether the other bid, which was declared to be valid.
Yeah.
By the approving authority at this point,
First they have declared is invalid, and
By the-
thereafter
by the settling authority,
they have
primary
declared
authority.
is valid.
Then they have said this is valid.
As
On
per the
two
order
counts-
passed by this court,
Sorry,
as per the orders passed by this court on 29/5/2018.
that was the order where the learned single just said that you consider it afresh. But the certificate, so far the certificate of Bakija clearance certificate, that is there in the file of order. So you consider this, and you then decide regarding other certificates, whether these are valid or invalid, and take the call. Thereupon, they have decided. My responsible submission is, while deciding afresh, they took into account certain documents, certain reports, which were subsequently procured pertaining to those certificates. Whether this vitiates the decision. This is the point. Whether that vitiates the proceeding. Kindly see, my lord. For that, it will be pertinent if I take your lordships to the order which was issued by the settling authority, approving authority, so to say, by rejecting my bid, my tender, and accepting respondent number 7's tender. That order is settling authority, way to put. Lordship will kindly come to, which was put to challenge, that was the interim, that is the 148 at page 148, Lordship will kindly come to,
13/10/2018. 13/8/2018.
No, 8/10/2018.
8/10.
Yes. 148 page, Annex 12. What you got it, my lord?
Yes.
Yes. Let me place this order, my lord. It will, 2 pages, it will make the whole thing clear, and then I will develop my argument. Read letter number Sessions of dated 29/6/2017. My lord, I'm reading this, kindly once read with me. This,
8/10/2018.
yes, yes,
Page 148.
yes. My issue, I will handle it, my issue, why I am agreed. Read letter number so-and-so dated 29/6/17. DC Kamrup Amingaon issued tender notice for settlement of Part 3A Lower Brahmaputra Fishery for 7 years, with 7/7/2017 as the submission date of tender papers. In response to the said NIT issued by the Deputy Commissioner Kamrup Amingaon, 6 members of cooperative societies NGOs submitted the tender papers along with relevant documents. Accordingly, DC Kamrup Amingaon submitted the comparative statement, etc. for settlement of 3A Lower Brahmaputra Fishery to the Government of Assam in Fishery Department with all the tender papers, relevant documents. Accordingly, the records submitted by the DC Kamrup Amingaon have been gone through, and it is found that Messrs. Bahari Reserve Gaon Min Sambai Samiti Limited was the 3rd highest bidder in terms of bid value, offered with an amount of rupees 1,48,47,777 for 7 years, that is at the rate of 21,21,111 per year. The rates offered by the other tenderers are given below. And we can skip Nomasudra, I am 3 here. Serial 3, my is 36,47,000. Respondent is 2 here. Out of the rest 5 tenderers which submitted 4 tenders, namely Gonapara FCS Limited, Messrs. Somoria Machhajibi Welfare Society NGO, Messrs. Ma Ganga NGO, and Messrs. Lower Part Brahmaputra Min Mahal Sambai Samiti Limited were not found to be in order due to non-submission of required documents along with the NIT as per the comparative statement submitted by the DC Kamrup Amingaon and were disqualified. Thus, as per the CS submitted by the DC Kamrup Amingaon, only the Messrs. Nomasudra Fishery Cooperative Society, me, that is, was reported by DC to be in order. However, the government decided to go ahead for retender as the valid bidder, that is Nomasudra Fishery Cooperative Society, quoted very much lower bid value of rupees 36,47,000 for 7 years. So, pausing for a moment here, authority was satisfied that my bid was valid, but it is too low. That's why they wanted that.
Decided to retender.
So, therefore, this opinion was already formed, going by the records, that this was valid bid, no doubt, but it is because the bid amount is very low, we will not go by it, we will go for test tender. We came before the Honorable Court, court said that you shall allow, taking into account these tenders only. That was ultimately, that's how the matter went back to them. Accordingly, we did letter number Sessions dated 10th August 2017. The DC Kamrup Amingaon was instructed to initiate the process for retender. So they issued retender, that's how we approach this Honorable Court. And also to allot the said fishery to the present lessee at the rate of 10% enhanced rate on temporary basis till regular settlement is made. Meanwhile, Messrs. Bohori Reserve Gaon Min Sambai Samiti Limited filed writ petitions bearing number 793417 and 489617, wherein the Honorable Court concluded that the Bakizai clearance certificate of Messrs. Bohori Reserve Gaon Min Samabay Samiti Limited is available in records. And no other consideration in this regard, no further consideration in this regard shall be made by the state respondent as the said certificate of Messrs. Bohori Reserve Gaon Samabay Samiti Limited is part of the record which mistakenly attached with the tender of another bidder, namely Govinda Sarkar. State respondents were also directed to make a fresh consideration of the matter. These cases were disposed of by the Honorable High Court with an order dated 29/6/2016 with a direction that the settlement of the fishery shall be made with the valid highest bidder after completing the required verification as observed by the Honorable High Court. Pertaining to the caste certificate, fisherman experience certificate, and 100% actual fisherman certificate of Messrs. Bohori Reserve Gaon Main Samabay Samiti Limited, the Honorable High Court directed the state respondents to examine the entire matter. So this was open. Only in respect of Bakizai, court said that since it is there, you can consider. No further question should be raised there. That was the view of the learned Chingulia. Accordingly, the matter was referred to the DC Kamrup. Now here, lots of you kindly see. They have taken back the file for consideration. Then they again process the matter. How? Accordingly, the matter was referred to DC Kamrup Amingaon for submission of report, with views and comments from ARCS Borpeta, Vide letter number such and such dated 6/6/2018. ARCS Borpeta Vide their letter number such and such dated 7 June 2018 informed the DC Kamrup Amingaon that the Messrs. Bohori Reserve Gaon Min Samabay Samiti Limited is composed of 100% actual fishermen belonging to the SC community. Further, it is also stated that fishing is the main source of livelihood of the members of the Messrs. Bohori Reserve Gaon Main Samabay Samiti Limited. Further, it is noticed that the caste certificate is also available in the records. They have not considered the caste certificate is available. It is also seen that Messrs. Namasudra Fishery Cooperative Society Limited, who is the main contender in this case, has offered a bid value of rupees 36,47,000 only for 7 years. Their bid is not only invalid, now say, because Bakizai certificate and fishing experience certificates are not issued by the competent authority. Considering the terms and conditions of the tender, but any consideration to settle this fishery with the Messrs. Namasudra Fishery Cooperative Society will cause a huge loss of government revenue to the tune of more than rupees 1,12,777, which will be grossly detrimental to the public interest. Finally, Vide their order dated 38/2018 in their order in WPC so-and-so, the Honorable High Court directed the settling authority to finalize the settlement process. As per the instruction of Honorable High Court, the matter as well as the documents of Messrs. Bohori Reserve Gaon Samabay Samiti Limited were further re-examined in the Fishery Department. That is, it is seen that all the required documents in respect of Messrs. Bohori Reserve Gaon Min Samabay Samiti Limited are available in the file, including Bakizai certificate, clearance certificate, and caste certificate, experience certificate issued by the ARCS Borpeta. Thus, after verification of the relevant documents available in the file, Messrs. Bohori Reserve Gaon Min Samabay Samiti Limited is found to be valid, highest bidder, and their bid value rupees such and such for 7 years found to be highest valid bid among all the bidders, bid values offered by the respective bidders. Therefore, settle with the respondent. Now here, Lordship has seen, my lord. They went to collect reports, took into account those reports, which were subsequently obtained, and thereupon they came to the conclusion that these documents are there and these are valid documents. In my respectful submission, this is unauthorized. They could not have taken into account all these. they could have taken into account all the documents which were already there. They should have formed an opinion their own.
At the first instance,
My lord.
this Bari or whatever the name,
Yes. Bahari.
Bahari Reserve, Gaon MSS,
Yes.
it was, his bid was treated as non-responsive on what ground?
That these documents were not there.
Which documents?
Bakija,
Only Bakija?
no, one more. Bakija, experience certificate and fishing experience certificate. Bakija and fishing experience certificate. Those were not there. That's why if we 137 can see, page 137.
And after the remand by the High Court,
Yes.
the matter was taken into consideration, or they, since the High Court finding was already there, that the Bakija certificate is already there, you need not to again reassess it. And so far as regarding certificate, caste certificate.
Other
or whatever
certificates
it
you
may
can,
be, or experience certificate, they have re-looked into the matter and
Yes.
found yes, that is there.
yes, that is there. So far the others, but so far the Bakija certificate is concerned.
Bakija, the court has already said consider it.
My lord, yes, that was the single judge's view. We approached this honorable court.
If the your
Division
challenge
bench.
was by way of review and then appeal.
Yes,
And all dismissed.
all dismissed. And while dismissing the appeal, there also the division bench made an observation.
What of them?
So in my response submission,
What is that of them?
yes, kindly see that. Quote say to page 2. We'll come to 37 later on. Our division bench order to. Division bench to put black. Right? That's it. Well, Joe. Then I have a copy too. Then I copy too. Page. Well, Lordship, we come to. That judgment has been referred to. I'm sorry, my lord, the division bench has not been filed along with the. But then at page 222, the landed single judge has referred to. Paragraph 10, my lord. During the pendency of this writ petition, the petitioner had filed review petition number such and such against the order dated 29/5/2018 of this court, whereby the earlier 3 writ petitions were disposed of. This court, however, with the order dated 27/9/2021 had dismissed the aforesaid review petition. Upon such dismissal, the petitioner has preferred a writ appeal bearing writ appeal so and so. The Honorable Division Bench, however, with the order dated such and such had, however, dismissed the appeal by observing that since the challenge to the settlement in favor of the respondent number 7 was pending before the single judge, all the relevant factors and aspects would be examined in the writ petition. So in my response submission, this particular observation of the Honorable Division Bench kept the matter open.
Which matter?
This including the issue of sealing the Bakija certificate, that there need not be any further consideration. When the issue arose from there only, that review was filed on that count. So what happened, my lord? Background facts little is required to be placed. All the documents which the tenderers relied in their respective tenders were examined by the tender settling authority, the board, what they call it? Committee. Tender Evaluation Committee. The Tender Evaluation Committee, while looking into the papers, all the members put signature in each and every paper which they have found, including the tender itself, which they have seen. So thereafter, the tender evaluation committee came to the conclusion that this Bakijai certificate is not there in case of response number 7. And it was detected here only that this was in some other file when it was sent to this board. The question is, we raised the question, had it been there in that other file also, then in that case, the tender evaluation committee members must have put their signatures in that document also. Because in all other documents, their signature appears. Those were available on record in any of these files. But this particular document did not contain the signature of any member. We have given this. Kindly see at page 116. Bakijai certificate, no, MOA. Oh, it will, no? Yes. This is the photocopy we obtained at page 116. It didn't contain the signature of anybody. Whereas in other documents at page 115, Lordship will find the signatures of the member committees. Yes, sir. Therefore, my lord, a serious doubt arose. Yes, we consider that this could have been there in any other file if at all, but this must have contained the signature of all the members of the evaluation committee, because who append it, they put their signature in every paper. In every paper, in all others. I have given those photocopies. It will appear the signatures of others. But in this document, which photocopy obtained, there was no signature. None of them have put the signature. So presumption will follow that this was not there before them on that day. This has come on later on. And in the guise of that it is mixed up with another file. And there was some fishy. This is apparent on the face of the note prepared by the authorities, which were obtained by RTI. Whereupon this honorable court, in the single bench, had to say that the additional secretary should not be allowed to participate. There is something doubtful. What happened, my lord? They prepared a note at page 128. 128, Lordship will kindly come to first. 128 at kindly see, my lord, this is the report prepared and sent, prepared by the additional secretary fishery department at first. Annexer 7104 and 128, Lordship will kindly see. Serial number 2, Bohari Reserve Gaon Min Samabhai Samiti Limited, serial 2, my lord. In response to NIT, issued by DC, this is the status he is discussing. Number 2, Bohari Reserve Gaon Samabhai Samiti. Society has offered the second highest bid of rupees Sasansas, but the society has not submitted fishing experience certificate and Bakijai clearance certificate. Hence, tender is not valid in terms of NIT. That was a categorical finding recorded. My lord, little above Lordship will find in the third para, office has also prepared the checklist, which may be perused at serial 419-420C. Tender notice at flex assumptions from the above it is seen that altogether 6 tenders were submitted in response to NIT issued by DC. The status of each tender is shown below.
What is this?
Considering all
You
everything,
are reading 128.
128.
What about 137?
Then kindly come to 127, 37. That is the relevant thing.
Yeah.
Yes. Then subsequently, by hand, they corrected it and they have put in, it is there. There appeared the discrepancy. Here, kindly see, at page
That
137,
we have seen,
sorry,
that we have seen.
yes, my lord. So, whether certificate, just, my lord, I am pointing
The
out,
certificate,
but
but
the
the society
certificate,
has submitted fishing certificate and not Bakayji clearance certificate.
not Bakizai clearance certificate.
Yes.
They come back to that the society has submitted fishing experience certificate, not Bakizai clearance certificate. Then,
Okay, everything remains same.
Hmm?
Everything remains same.
not Bakizai certificate. Not Bakizai certificate, clearance certificate. So they say that Bakizai certificate was not there.
Experience was there.
Fishing experience certificate was there. Bakizai certificate was not there.
Yes.
This is, therefore, my lord, first thing that page 139, lordship may kindly come to, this was the note sheet we obtained. There was a lot many flag B, so and so cooperative statement appeared. A2. Huh? The society has not submitted from bottom, my lord, the lordship will file the Roman 2. The society has not submitted the Bakizai certificate and fishing experience given in is actual fisherman certificate issued by ARCS. So it was their finding that Bakizai was not there. Bakizai certificate was not there. Now, can we see the comparative statement which was prepared by the primary authority? Page 80, 80. Submission of comparative statement, yes. Yes. But it was forwarded to the Commissioner and Secretary of Fishery Department by letter dated 12/7/2017. And
Yes.
here, lordship will see all the photocopies are there regarding 52. Lordship will find. Wait, Maludas, yes. Malada page 82, the 2 columns, first column. If it is readable in your lordship's copy, as per certificate in the 1, 2, 3, 4, 5th column. Not submitted. What they say, first copy, my lord, here, experience certificate of fishing. 4, there is a column 4. Experience certificate of fishing, that is column, that should be column 5. 1, 2, 3, 4, 5, yes. Not submitted. And then caste certification. And lordship will find as per certificate issued, Bakizai certificate not submitted, right hand column, my lord. Last but one, right hand column, not
Yes.
submitted.
Yes.
So that's why they found that this is invalid. And they only said that only valid tender is mine.
Yes.
Therefore, my lord, the this issue was placed before this honorable court in a division bench in a review appeal against. Then this honorable court said, since the issue is already there, all the points that may be raised will be looked into by the learned single judge. But the learned single judge here thought it not proper to open that because already the
Division bench.
division bench dismissed my appeal. In my respectful submission, my lord, notwithstanding the dismissal of the appeal, the observation so made has its relevance. That should have been taken in its positive, as a positive observation. In that respect, the honorable court should have looked into it more particularly when there is glaring discrepancy. As I had just pointed out, in each and every paper, the tender committee, evaluation committee members have put their signatures, but that particular certificate is still lying, no signature. It was there.
Yes.
And regarding other things, other certificates, they have relied on the reports of the authority.
Right.
That is my limited, my lord, arena wherein I can only come before your lordship. Therefore, in my respectful submission, the learned single judge committed an error here. Yes. Ultimately, weighing the amounts,
No.
if the,
You have case on merits, there is the question of money.
exactly, that is my case. I'm deeply obliged. Well, if I am found to be valid with that, he is found to be invalid with that, things goes there.
Will pass an order.
I'm deeply obliged. I'm deeply.
Item 7.
Yes. 4 and 5, not sir. Okay.
Item 7.
Thank you. Wait, return of notice of answer respondent for 3 more weeks.
Item 8.
There is a delay of, my lord, 89 days in filing this appeal, my lord.
Note. Reasonable. Registered ADM Dasti Gold.
My lord.
For admission, item 9.
In 9, my lord.
Affidavit, what happened?
My lord, affidavit is ready, my lord. It will be filed during this week, my lord.
It's filed
During this week, my lord.
during this day.
Week, my lord.
Week. Mr. B. Sharma, consider very important. Respondent number 2, 4 and 5 has submitted that. Yeah, Mr. Sharma, appearing for the state, has submitted that the counter affidavit would be.
On behalf of respondent number 1.
Counter affidavit would be filed within a period of 1 week.
Obliged.
That's after 3 weeks. Okay.
Item 11.
May it please your lordship, my lord, hearing this case, my lord, we have filed IA 736 2025 as per order dated 19/2/2025 to stock off the respondent number 4 and 5 from the cost title. My lord.
No, no. It is not. Yes,
My lord. My lord, I may be allowed, my lord, will submit, my lord.
allowed.
My lord.
Now come on merits.
My lord, here in this case, my lord, we have we have challenged the, my lord, the constitutional validity of the 96 Foreigners Tribunal Order
On what
1964.
ground, sir?
My lord, the Foreigners Tribunal Order, the procedural law.
Procedural.
Yes, my lord. Procedural law and order 3 of the same provides that procedure for disposal of a reference and tribunal shall issue a notice along with a copy of the main grounds. But the tribunal is totally, my lord, Foreigners Tribunal Order is totally silent in defining the what is main ground, my lord. And
Challenge it before the, if we are agreed by the tribunal's order, challenge it before the report.
my lord,
Challenge it.
we have challenge here, my lord.
You challenge this, essentially your grievance is that this procedure adopted by the tribunal is not fair.
My lord.
This is what your main contention is.
My lord, the law is defective, my lord. That point is raised in each and every case, my lord, in the before the tribunal, before the my lord, FT cases, my lord, before the division bench, not considered, my lord. The law is defective, my lord. So let the other side file a response to the.
There is, sir, if we are in requirement of other side response, certainly we'll ask for that. First of all, you have to satisfy us.
Yes, my lord. The law is defective, my lord.
Law is defective, yes.
My lord, there is no whisper at all how the cases are coming up, how the investigation is carried out, how, my lord, on what basis the my lord, tribunal is taking cognizance of the case.
Sir, kindly consider, sir, this para number 1 of the writ petition. Of your petition.
My lord, para 1. My lord.
Yes.
The instant writ petition under Article 226 of the Constitution has been filed by the petitioner,
Yeah.
essentially praying
Come on
for.
the next page, sir. And third line,
My lord.
the contention of the petitioner.
Yes, my lord. Essentially praying for protection of fundamental rights granted under Article 14 and 21 of the Constitution of India in respect of persons whose citizens has been doubted.
The third lines from above,
My lord.
from start, third line. The contention of the petitioner.
My lord. Hard line, man.
Page number 5. Third line.
My lord. The contention of the petitioner is that having no appropriate provisions in the Foreigners Tribunal Order 1964 to discharge the initial owners of the state in collecting materials of doubt, a suspected person before making a reference, the same has appeared to be violative of fundamental rights granted under Article
This is
21.
main, your grievance is there and therefore you have prayed that it should be reframed. A direction be issued to reframe this 46 order.
Well, there is lapses in the provisions, my lord.
Yes, this is what you are saying, that the provisions are not foolproof and therefore.
My lord, it may be, my lord, pack down and reframe, my lord. They can reframe, my lord.
Yes, why not? But whether the court can give such direction.
My lord,
In fact, my lord,
when there
that
is-
contention is not correct, my lord.
आपसे पूछे जब बोलना
My lord. My lord, if the law is not, is defective, my lord, this court can set aside, my lord.
But sir, the court has already taken into consideration this procedure and they said that it's fair. The Supreme Court has already appointed that the procedure is fair and
No, my lord.
not offend any
My
constitutional
lord,
provision.
we are finding that the procedure are not
Sir,
proper, my lord.
you may find it, but there is a Supreme Court after examining all this and they said it's okay, it's not offending any
My
constitutional
lord.
provision.
My lord.
That is there, sir.
My lord, the provision does not define what is main grounds, my lord.
Maybe,
How the
sir,
cases are
once the
coming up.
Supreme
See,
Court.
Supreme
once
Court
the-
has not given reason, my lord.
Oh, gotcha. So now
Not
we'll
given
ask the
reason.
Supreme Court to give us reasons.
Proper, my lord, discussion is not there, my lord.
Sir, kindly consider this. 2005 SCC is 665.
My lord. Yes, my lord, the Sonwal one case, my lord.
One case. Do you have a copy of it?
My lord, I am not having copy at this stage, my lord.
Supply.
Lordship may take up, my lord, any other day, my lord.
Why any other day, sir? Today we are hearing you. Number one, 2005 SCC. Now come to page 720.
My lord, please.
720.
My lord,
720.
my lord, paragraph.
Just 3 lines above para 74.
Yes, we consider it necessary here to briefly notice
No, sir.
the paragraph
3 lines above, 3 lines above.
My lord.
In
In
our,
our opinion, the procedure under the Foreigners Act and the Foreigners Tribunal is just, fair and reasonable, does not offend any constitutional provision.
what remains now?
My lord,
Still it is open for us to look into again.
My lord.
Give a
my lord, in fact, we approached the Honorable Supreme Court, and Honorable Supreme Court has remanded before this Honorable Court for
not
consider.
remanded, sir. You have simply Article 32 mein you have filed a petition Supreme Court you approach the High Court. You approach the High Court and we are examining it. That's all. The Supreme Court has not the order is there. Supreme Court order is there.
Yes,
We have already seen.
my lord,
Page number 79. Annexure 2.
my lord.
A petitioner will be at liberty to move the High Court for seeking appropriate reliefs,
Yes, my lord.
leaving it open to the petitioner to do so. The petition under Article 32 of the Constitution disposed of at this stage. Okay, they have granted you liberty. You have come here.
My lord.
There is nothing, sir. And your main contention is that the procedure is not fair. That the Supreme Court has already examined it and
My lord.
in so unequivocal terms said it is fair. What remains to examine before us, sir?
My lord, we have made some pleading, my lord.
A full bench of this court in this Muslim Mandal have also laid down guidelines. This is what you have to do.
My lord.
The investigating officer has to do this 97, 98 on which you have also placed reliance. What remains then, sir?
My lord, the Muslim Mandal judgment in many cases not followed, my lord.
Sir, not followed.
Not
and
followed.
challenged it, sir.
And my lord, there is another judgment of Sarvanda Sonwal 2, my lord.
Mr. Sikdar, is this the ground for challenging the
If-
validity of the this order 46, sir, 1946? That they are not following it, then the court will look into it. If they're not following it, it casts upon a duty of the tribunal to look into it. If they have not discharged their initial burden, they can very well pass an order in accordance with law. And even though if the foreign tribunal is not doing the appropriate remedy for you to approach the court,
My lord.
sir, it is simply because you have filed a 300-page petition, we have to consider it without even looking into the merits of the case. It can't be done.
My lord, the Sarvanda Sonwal 2 judgment, there has been a specific observation.
Sir, what observation? Yes,
lord.
you have referred to it and we
My
have
lord.
gone through that observation. What is that
My lord,
observation?
the state is to discharge the initial burden.
That is all law, sir. That is the law.
That has not been done, my lord, without
What has
specific
been done?
provision, my lord.
Challenge the
How it can be,
individual
my lord?
case where it
They
has
are not
been
following
done.
it.
Then you have an appropriate remedy where they are not doing. The court will look into it. The tribunal will look into it. If they are not discharged the initial burden, they will do it, sir. Yes, sir.
Yes, my lord.
Yes, you have to say something.
My lord. My lord, I have made some, my lord, statement as well as documents which goes to show that the observation of the Supreme Court is not based on records, my lord.
So
My lord,
you mean to say that we review this judgment of Supreme Court? Is this the power?
no, my lord, that we can.
No, sir, you are asking for
You cannot
this.
urge for that. My lord.
You are asking for this only.
My lord, lordship, I leaving in lordship. We have to approach the Supreme Court again, my lord. We have to approach the Supreme Court again. We will not leave it, my lord. Yes, my lord.
What do you want?
My lord, dear lordship, I leave it.
No,
Lordship.
Lordship, what Lordship will do? Lordship have already said. We have nothing to do. आप हमसे क्या करवाना क्या चाह रहे हैं जो हम नहीं कर सकते वो?
No, lordship will dismiss the petition.
You
If
need not to
not-
say we'll dismiss it. We are giving you a chance to either to withdraw it, otherwise we are
No,
going
I will
to
not
dismiss
withdraw, my
it.
lord.
And we are going to dismiss it with heavy cost because the law is already settled. And since because you have filed a 400-page petition and you are wasting the time of the court, sir. What type of petitioner he is? And that also PIL petition. We can't encourage such type of petition, sir. Simply because you have filed a 400-page petition
My lord.
and
Yeah, my lord, I may be allowed to.
be afraid by it, we'll issue the notice and then we'll keep this matter pending.
My lord, I may be allowed to do.
After attempting to argue the matter for quite some time, particularly in view of the law settled by the Honorable Supreme Court in Sarbanand Sonowal, which is Union of India,
It will be.
reported in 2005, 5 SCC 665. Planning Council for the petitioner wants to withdraw this petition, dismissed and withdrawn.
Item 12,
Yes,
Lordship, this appeal is directed against an order passed by the learned single judge in WPC 7893 of 15, whereby Lordship, the CCIS claim, central, this is subsidy claim, was allowed. Now, Lordship will find the impugned judgment at page 23.
Para.
The relevant paragraph, Lordship, will find, if your Lordship will come to page 39 from paragraph 27 onwards.
Yeah,
Now, in this appeal, Lordship, we are primarily required to look into what would be the definition of an existing industry and what is a new industry, new unit, Lordship. Now, as it is, Lordship, the scheme of 2007, which granted the capital subsidy scheme, Lordship will come at page 156. That will, Lordship. (156) and the relevant page will be 157.
Yes.
157, Lordship. Lordship will see, this is definitions. 4B.
Yes.
New industrial unit means an industrial unit for the setting up of which effective steps were not taken prior to 1/4/2007. An existing industrial unit would mean an industrial unit for the setting up of which effective steps were taken prior to 1/4/2007. Now, this scheme having come into effect from 27th July 2007, there was an amendment to the definition clause, which your Lordship will find at page 164. And this amendment came into effect in the same year, in the month of September. Now, new industrial unit means an industrial unit which commences commercial production on or after the first day of April 2007, but not later than 31st day of March 2017. And existing industrial unit means an industrial unit which commences commercial production before 1/4/2007. Now, if I may take your Lordship to paragraph 7 of the writ petition, which is your Lordship will find at page 61. If I may take your Lordship to page 61 for a moment, it is a writ petition filed by the respondents herein. So, I'm just reading it. The petitioner number 1 partnership firm received FM so and so a permanent registration certificate from the general manager, District Industries and Commerce Center, Kamrup, Bamuni Medan on so and so, as a conversion from Industrial Entrepreneurs Memorandum to Entrepreneurs Memorandum on 11/7/2008, whereby the date of commencement of production was shown to be 1/7/2007. Now, Lordship has noted the commercial production started on 1/7/2007.
Effective steps.
Lordship, if I may take your Lordship to that
Effective
CCIS to the at page 156 once again, Lordship. (157), Lordship.
Yeah.
Effective steps means one or more of the following steps. That 10% or more of the capital issued for the industrial unit has been paid up. That any part of the factory building has been constructed. That a firm order has been placed for any plant and machinery required for the industrial unit. Now,
You have non-fitted him because those effective steps is taken at a new place, location, and not at the
No.
existing
so
location.
Lordship will kindly bear with me, Lordship.
Yes.
Lordship, I would again take your Lordship to the definitions as given on 27th July, that is page 157, the top part. Top part. Lordship has been referring that page. Industrial unit means a new industrial unit means an industrial unit for the setting up of which effective steps were not taken prior to 1/4/2007. Now, this notification came on 27th of July 2007. And the amendment came in September 2007, the same very year. And the petitioner started his commercial production on 1/7/2007, and he has already availed a subsidy as a new unit, which I'll take your Lordship to page 61. Page 61, and the relevant part, Lordship, will find at page 62. When did he file an application? Lordship had seen the top line. 27/7/2009, claiming Central Capital Investment Subsidies under NEIPP 2007. That is after there was an amendment to the definition. Before the respondent number 4 so and so, and the approval of the claim of the CCIS under NEIPP 2007 by the state level committee was given on 18/12/2009.
Who is appearing for the other side?
Lordship, Learned Senior Advocate Mr. P.K. Goswami had appeared. I've not seen him today, Lordship.
Caveat is there.
There is a caveat, Lordship, yes.
You have supplied in the copy.
Yes, Lordship.
What caveat? Mr. Goswami has filed a caveat. Who has filed a?
I think Mr. Deccan. Because on the last occasion, he had appeared, Lordship.
Last occasion when this is
No,
the
no,
matter is listed for the first time for admission.
Lordship, this on the condonation of delay.
Condonation of this. Okay, but
Oh, Lordship, I can do one thing, Lordship. I'll inform him. Lordship can take it up on any other day.
not other day, today itself. We are hearing it finally.
Lordship.
Can't harass the investors in this manner, sir.
No.
Subsidy scheme is there and you are harassing the.
So ultimately, it is for your Lordship to pass an order. But
Pass an order, yes, certainly, but you have to also think it. In the northeast, for the promotion of the industry, some scheme is there. You are on technical grounds, you are discouraging the investor. That's not correct. What timing?
Lordship,
Ask the, inform the.
I will inform Lordship.
Item 14.
Yes.
My lord, in this figure, my lord, tender already uploaded, my lord, on 5/3/25, my lord. Last date of submission, closing of the tender is 1/4/25. 1/4/25. And amount has been revised, my lord, from one for the latter part of work, my lord. Balance work, my lord, 1,57 lakh
When
already.
the date for opening of the bid?
Start of closing that is on the same day, my lord. And period of completion is 8 months.
Yeah, you come after awarding the contract to one contractor, then we'll pass some order.
My lordship.
Based on, by I think so 7th of April, you will be able to finalize.
When, my lord, some
Why?
First, then,
First and then seventh तक हो जाएगा.
my lord, may on 9, my lord.
Ninth of April.
Lords, oblige.
The concept of the respondent has submitted that the NIT has already been issued. And the last date for submission of the bids is 1/4/2027. 25. Full stop. Place this petition on 7th, 9th,
The 9th of it.
9th of.
I'm so obliged, my lord.
Item 15,
No voting is happening. Okay. Initially, Bonic appeared. Now, it's not displaying.
The last occasion. The input for the appellant has withdrawn from the case by stating that the client has already taken the brief from brief and no objection certificate has also been issued. Today also none is appearing on behalf of the appellant.
Lordship. They may not be interested, Lordship. Lordship may close
Need
it.
not be somebody come and say, we are not interested. We are also not interested to keep this matter pending.
They know actually. All fiscals, they are filing for the.
None is appearing on the and the writ of appeal is dismissed for non-prosecution.
Highly obliged, Lordship.
Now you can raise the bill.
item 16,
My lord, kindly read the last order on 24/1.
Yeah, payment. Yes.
My lord, the proposal had been processed, my lord, but in this financial year, probably it will not be possible to make the payment, my lord, but
This
it has
financial year, which financial year?
this financial year, but it has been processed, my lord.
Process then,
From April 1.
Proposal,
give us assurance that in the next financial year you will make the payment.
yes, my lord, it will be done, my lord, in the next.
It will start from 1st April.
7 lakh rupees only.
No, it is 7 lakhs rupees only in respect of 4 petitioners only, because they are from 5 districts, my lord. In respect of 1 district, only 4 petitioners. In respect of 4 appellant, it is 7 lakhs, but in total, it will be more, my lord.
How much?
My lord, average, it will be around 2 lakhs per appellant.
Less than.
So
How
it is under process,
It's a
my
matter
lord.
of 1 or 2 crore rupees only. After all, 1 or 2 crore in the whole state of Assam,
Yes, my lord.
at most maximum.
So it is under process. It will be.
I think जेब खर्ची है सरकार की.
जेब खर्ची. Pocket money.
Concept appearing for that. You make it payment in the April.
Yes, my lord. In the next financial year, my lord.
Next financial year starts from April. You can't finger it on up to 2026.
Yes, my lord.
This can't be there. Yes,
My lord, it has been proposed in the next financial year. That much instruction I have received, my lord.
learned concept of the respondent. The respondent to state has submitted that. FOC proposal against financial sanction of rupees 7.46100 lakhs under the head accounts has already been sent and have already been sent for the purpose of payment of arrears to the payment of arrears of honorarium to the appellants. And council has submitted that the arrears would be paid to the appellant during the next financial year. The communication received by the Council of the State through Director of Health Services is taken on record. The dated 8/3/2025 is taken on record. So we expect, it is expected from the government that the arrears of the payment of arrear of honorarium to the appellants will be made by the end of April 2025. List in the first week of May 2025.
Obligation.
If we have expected, it means it's a order.
Yes, my lord. Obligation.
Yeah, have that order passed by the.
Yeah, that
Not yet.
is yet to be
Item
uploaded,
17.
my lord. I have
Be
checked,
approved, I have inquired.
I have
yesterday
not yet
also.
uploaded, my lord.
So what
I-
are the specific directions?
Yes,
Because
my
we have to assign 1 or 2 courts for that purpose.
Yes, my lord.
Then we'll pass an order or either on the administrative side or judicial side.
My lord.
That the matters of the bail application shall also be heard by that court.
Yes, my lord.
Let the order come.
My lord, today morning also I checked it up, my lord, not yet.
After a week.
Yes, my lord.
My lord, by this time it will be uploaded.
I can.
Also. Item 18.
Yeah, please, your lordship. My lord, may kindly give me 2 weeks time to file a report.
File reply.
Yes, ma'am.
Earlier also you sought time.
One more chance, ma'am. One more chance.
How many chances?
This last chance, my lord.
Last chance.
Yes.
Okay, let's considering for the respondent place of more time to try to counter to that. I paid for the after 6 weeks.
Item 19.
If you apply.
My lord, let this matter be taken up after some time. Senior counsel change order is in another court.
After some time, we don't have any case.
My lord, then already affidavit in reply was filed by us in this matter, my lord.
Payment has already been made.
19%.
You are for the Employee State Insurance Corporation.
Yes, my,
Payment has already been made.
my lord.
You have already cleared the arrears or what?
No, that is done, my lord. Contempt proceeding has been closed, my lord. Now, my lord, on merit, my lord. My submission is that, my lord.
The period is over.
No, she is walking, my lord. And I have come before your lordship against the order of Central Administrative Tribunal, my lord. And my lord, I will take your lordship to the operative portion of this order, my lord. At page 24, my lord.
24.
24. Last portion, my lord.
Yes.
Therefore, we direct the respondents to consider the case of the applicant afresh by treating the original application as a part of it and accommodate her at any place within the state of Assam as per their policy and communicate the decision to erect within a period of 4 weeks from the date of receipt of a copy of this order, my lord. And accordingly, my lord, we have allowed her to work in my corporation, my lord, and she has been working till today, my lord.
Wow.
And on that, I will
I will make submission, my lord. Just a moment.
Yes.
My lord, I will submit, my lord. The respondent number 1, my lord, was appointed in our hospital in 1/1/2006. As a, my lord, insurance medical officer. Thereafter, in 2011, she was promoted to chief medical officer, my lord. Thereafter, in 2015, she was posted as chief medical officer, NFSC. And thereafter,
First, she was appointed on the post of
appointed the post of ESI medical officer, insurance medical officer, my lord, on 2006. Insurance officer, my lord. Thereafter, she was promoted
medical
to,
officer. It is the-
yes. Thereafter, she was promoted to chief medical officer.
And she was posted where?
Beltola, my lord, Beltola ESI hospital.
In
Guwahati.
2006.
2006, my lord.
Beltola.
2011, my lord, she was promoted to chief medical officer.
2011.
11.
Promoted to chief medical officer.
Officer, my lord. Thereafter, in 2015,
To just a CMO and posted at
same place, my lord.
same place, Beltola.
Yes, my lord. And
Yes.
2015, my lord, she was posted as chief medical officer NFSD. And my lord,
Medical CMO at
same hospital, my lord, Beltola, ESI hospital, my lord.
NFTC, what your
It is non-functional selection grade, my lord.
non-functional scale. Selection grade. At Beltola.
Beltola, my lord.
Yes.
Thereafter, my lord, on 23/12/20, she was promoted to chief medical officer, my lord. And on 27/12/2022, she has been transferred to Darjeeling, my lord.
Chief medical officer.
Officer. And on 27/12/2022, she has been transferred to
Chief medical officer at Beltola only.
same hospital, my lord.
Okay. And thereafter,
And she has been transferred to Darjeeling, my lord.
Darjeeling.
Darjeeling, West Bengal, my lord.
Wide order.
27/12/2022.
2022. Yes.
And because of her qualification, my lord, her services urgently needed, my lord, at Darjeeling Hospital, my lord, West Bengal. Thereafter, my lord, against that, she came to the Central Administrative Tribunal, my lord. And Central Administrative Tribunal has passed an order, my lord. I will take you not to see that. At page Annexure 1, page 20. And operative portion is at
That you have read just now.
page 24. Yes.
Yes.
Page, paragraph 5, my lord, last portion. Therefore, we direct the respondents to consider the case of the applicant reference by treating the original application as a part of it and accommodate her at any place within the state of Assam as per their policy and communicate the decision so arrived within a period of 4 weeks from the date of receipt of the copy of this order. And against this, we are before your lordship, my lord. So my submission will be very short, my lord. Yeah, I will take your lordship to wait a minute, please.
Yes.
And I will take your lordship to page 30, my lord. That is Annexure 3. That is the transfer posting policy of the department of the corporation, my lord.
Yes.
Paragraph 2.
Yes.
This transfer posting policy is issued with the approval of Honorable Minister for Labor and Employment Chairman, ESI Corporation, and shall come into force with immediate effect. It says, my lord, all the transfers and posting will henceforth be regulated in terms of this policy till further order. The policy may be brought to the notice of all officers and employees. Thereafter, I will take your lordship to page 36, clause 8.
Yes.
Clause 8, it says tenure. 8.1. All clinical posting of doctors can normally be for a period of 6 years, provided there is no serious complaint or misconduct against the doctor, or it is expedient in public interest to transfer him, her, before completion of the minimum tenure. This may be extended by the competent authority with specific reason for a further period of 3 years. So this provision is there, my lord, for extending the period for another 3 years. But in my case, my lord, in this case of the present petition and respondent, my lord, the department, the corporation has find no specific reason, my lord, to extend her service, my lord, for another 3 years, my lord. That is my case, my lord.
Normally for a period of a clinical posting of doctor shall normally for a period
For
of
6 years.
years.
And she has completed that 6 years period, my lord.
And it can be extended for 3 more years.
3 more years, provided, my lord, for some specific reason. And the department, my lord, find no specific reason, my lord, to extend her service, my lord. And I will submit another thing, my lord. My learned senior counsel has very rightly pointed out, my lord, before your lordship on 17/10/2023, my lord. May I take your lordship to that paragraph, my lord?
17/10/2000
2003 of your lordship's order sheet, my lord.
order sheet.
Order
Okay.
sheet. 17/10/2003. Paragraph 9.
Yes.
Paragraph 9, my lord.
Yes.
Learned senior counsel on behalf of respondent number 1 submitted that EICIC by office order on 23/2022 under memo number such and such dated 4/12/2020 brought her service as medical officer under the All India category with effect from 1/6/2018, and accordingly she is entitled for a period of 6 years for posting in same place, that is at ASCI Model Hospital, Beltola, Guwahati, with effect from 1/6/2018, and the said period of 6 years shall come to an end only on 31/5/2024. So that period is over, my lord. And department has find no specific reason, my lord, for extending her service. And my lord, her service, she is a qualified doctor, my lord. Her service is urgently needed at Darjeeling, West Bengal ESI hospital, my lord, because there is lack of doctor there, my lord. So that is my submission, my lord. Your lordship may pass appropriate order, my lord.
Yes. What remains that
My lord, in a transfer matter, we know our limitation. But then here is a good case, madam.
But sir, here you.
No, no, I'll come
I said up to 24.
No, no, my lord, I'm entitled to another 3 years. Their policy itself says.
Sir, policy itself says you are at a place.
No, no, lots of no, my lord.
Just Beltola since 2006.
No, that is okay.
From on different after promotion. 2006 to 2022 remain there, and now up to 2025 still you are remain here.
Yes, sir.
Remain.
No, my lord. Lots of kindly.
If you just a minute, sir. If you say since you are posting as a medical officer, insurance medical officer 2006, you are supposed to not 9 years. Then as a CMO, again you were promoted in 2011. From that date, 6 years. Then chief medical officer, 2000, again 6 years.
My lord, it is their choice to post me wherever they would like. But if the transfer order violates my condition of service, then certainly I can raise a grievance. Now, my lord, this Darjeeling, my learned friend has said that I am a qualified doctor. My service is urgently required at Darjeeling. My lord, Darjeeling is a DCBO, na? DC, my lord will kindly come to the proceedings of the meeting pursuant to which the impugned decision was taken. Before that, my lord, let me place the facts in my lord perspective. Now, first, my lord will kindly come to the transfer policy at page 30, which my learned friend has already referred. I'll refer to page 36.
Page 36.
I am in clinical posting 8.1, my lord. Now, all clinical postings, the tenure is 6 plus 3, 9. Then Milord will kindly come to page 38. 13.1. After completion of maximum tenure at an institution, the online ERP portal shall prompt the doctor concerned to compulsorily give option for choice of institution station posting as per provisions of this transfer policy. A list of doctors due for mandatory transfer shall also be made available through online module. Now, my lord, pursuant to this, I have exercised my option, which your lordships will get at page number 6 of the memo of appeal. Page 6. It is the case of the respondent itself. Sorry, department petitioner itself, my lord. Last two sentence at page 6. Accordingly, the respondent number 1 submitted the following option for consideration of her posting. The options are given herein under. There are 5 options I can give. I have given, my lord. ESIC Hospital, Model Hospital, Beltola, Dispensary, Nagaon, so and so, so and so, so and so. That is why the tribunal says, my lord, you consider her case as per the choice she has given.
Now even that 9-year period is already.
Not over. Not over.
How?
No. No, now, my lord, yes, I'm coming. So kindly give me 2 minutes time. Now, my lord will kindly come to page number 319.
এইকেইটা যে আমি পঢ়িছিলো তোমাৰ কথা যে এইকেইটা এই পাঁচটা যে ফাৰ্ষ্ট দিছো এই পাঁচটা যে চইচ দিছো
Yes. 319, my lord, it's a part of the additional affidavit.
319.
Yes. Director General has ordered promotion of the following GDMO sub-cadre absorbed in ESIC hospital working as CMO in level so and so of pay matrix of so and so to CMO non-functional selection grade in level 13 in the payment, etc., etc., etc. Then Milord will kindly come to page number 320 at serial number 70 is the respondent applicant before the serial number 70, Milord.
Yes.
And kindly see the date is 2/1/2015. Now, most important is please come to page 321.
Yes.
Option shown in column number 4 was exercised by the individuals at the time of absorption. Subsequent to corporation approval in 174th meeting dated 29/5/18 from 1/6/18, all the absorbee medical officers are deemed to be in All India cadre. So now we are in All India cadre. So that is 1/6/18. From 1/6/18, we learned that 9 years has to be counted. So it will take us to 27. হেৰিখন কি হলে যে কিবা এখন তুমি দেখাইছিল 323.
Yes.
Yes. Milord will kindly come to page 322, Milord. This is a circular issued by the Milord ESIC Corporation.
Yes,
Now please come to para 5.
yes.
As stated in para 13.1 of the approved policy, the online system to prompt the doctors who have completed their maximum tenure to compulsorily give option for choice of institution station posting may not be fully functional as yet. Hence, all medical officers who have completed maximum tenure as per para 8.1 are requested to give options for posting. Now 6. As per para 8.1, there is provision for extension of posting at the present location for a further period of 3 years after completion of 6 years on clinical posting. Accordingly, such medical officers who have completed a period of 6 years but have not yet completed the period of 9 years may choose the institution of their present posting as the first choice with appropriate justification for such a request in the remark column and submit relevant document online. In all such cases, their request will be submitted before the competent authority for order. In case their request is not accepted by the competent authority, they will be considered for posting as per other choice submitted by them. My lord, let them do it like this. That they have not done, my lord.
That they're not, what is you have made it that your service condition is going to be affected?
Yes. Now what had happened, my lord? I am in a clinical posting. Now Darjeeling office is basically for, my lord, it's not something administrative in nature, my lord. Now that's why please come to that page 325, my lord. The proceedings. I am a clinical person. I am sought to be sent to a quasi-administrative job. There my job as a doctor is not required.
But that.
As kindly come to
in the this whatever their setup, the doctors are
They are-
discharging the administrative functions.
No, my lord, there are specifically, kindly have a look at this, then it will be clear.
It is not.
Transfer of medical officers from to DCBO in SIC. As per transfer policy for medical administrative post in ESIC, any medical officer holding the charge of IMO 1, IMO 2 or above, as per administrative requirement can be posted in as DCBO in charge in dispensary cum branch office of ESIC. There are 80 functional DCBO in ESIC. The medical officers posted in DCBO performs administrative natures, functions of administrative nature like scrutiny of medical bills, private hospital, etc. Hence, it is sensitive post and the need to be replaced after tenure of 3 years of service in as DCBO in charge. Hence, it is required to replace GDMO with medical officers, preferably non-PG, in various regions who have completed at least 3 years of service as on 31/3/22. All the present medical officers who have served the period of 3 years or more of posting in DCBO have been considered. I was not in DCBO. So my lord, idea was, since it is a job of administrative nature, in tune with the government policy, because he might develop some interest, therefore it is ideal to transfer. But I am a doctor. According the council's own submission is, I am a very good doctor. My service is required there for checking bills. So I think, my lord, in terms of the more আছে editor. They counted those also.
Yes, sir.
And moreover, my lord, there are some leave which is to my credit. Those have also been taken into account while computing the period. My lord. That is not permissible. Under the 8.5 of the policy. My lord. Page number 37. 47, no? Space, 8.5 million. All of them, the period of absence on account of EOL, study leave, under from so and so, everything, my lord, will be deducted while calculating tenure under term head tenure.
So how much that period was?
Yes, my lord, that we have explained. A paragraph. Page. Page number. 347, my lord, page.
একটু করে দিন নাকি?
My lord, that subpara.
একটু করে দিন।
From that in the instant case, somewhere in the middle, my lord, at page 347. In the instant case, the deponent has completed 6 years of tenure as on so and so, with a taking into consideration 590 days of approved leave of the deponent, while taking into consideration further extension of 3 years as per clause 81 of the circular, deponent can be retained at present place of posting till so and so, as the year being a leap year, the situated as such, the impugn order of transfer was arbitrary, for which the learned tribunal has rightly interfered.
So this 590 days.
Yes. My humble submission is, my lord, in terms of the tribunal's order, let them have due regard to the policy and pass a speaking order.
May I point out one thing, my lord?
Yes.
My lord, the respondent number 1, my lord, now holding his administrative post, not clinical. My
At
lord.
present.
At present, my lord, administrative post. He is holding.
Administrative post, which administrative? She is not having any clinical duties.
No, sometimes she is doing clinical post. Now my instruction is that she is doing administrative post. My lord. She is holding.
Apart from that clinical.
Yes, my lord, yes. Administrative post. And earlier, my lord, your lordship will find that page 331, my lord. She gave option for 5 places, my lord. Paragraph 8.
Yes.
That is ESI Hospital, Beltola, DCBO, Nagaon. That is non-functional, we could not accommodate her. DCBO, Mongoldoi.
That is the administrative post.
That is administrative post, my lord.
So she herself has gave this option for this administrative post.
Yes, my lord, but that on to that 5 posts, she could not be accommodated, my lord. And thereafter we send her to Darjeeling, my lord. And for such a long time, my lord, he's serving my Beltola office, my lord. So I pray, my lord, your lordship will pass appropriate order, my lord.
My lord, that is contrary to their own pleadings in para 6, page 9, my lord. Para 6, page 9 of their writ petition.
Para 6, page 9.
9.
Yes. But you have given this option of DCBO Mangaldoyi and DCBO Guwahati and DCBO
Yes,
Bairpeta?
yes.
That is the administrative post? These are the administrative.
No, my lord. Presently, I am holding a clinical post. It's wrong to say that I am holding a. Yes, I have given.
You have given.
Yes, I have given.
Yes, para 6.
Para 6, my lord. That petitioner, somewhere in the middle, it is pertinent to mention here that respondent number 1 applicant is working in ESIC Model Hospital, Beltola since 2006 and has been posted to a clinical post.
Order is over. With the consent of the party, the matter is heard at admission stage. Order is done.
Obliged.
Deep.
Item 20.
Lordship, pleading is complete, Lordship. Lordship may fix the matter for hearing. Other side is also on last occasion, they were not here.
Somebody is appealing.
Yes, Lordship. D.N. Sharma, they have filed a counter also. I have filed my rejoinder also in this case, Lordship.
Yeah, calculation, how you calculated this
Lordship,
amount of 1 lakh?
Lordship, this chart will make it clear that we have proceeded against 13%. He is not alone. So I want to bring this to record also.
Out of 2 lakh 88, how much amount?
No, total volume was more than 21 lakhs, Lordship.
21 lakh.
Lordship.
And
We have proceeded against 13%. This
proceeded against, that's right. Calculate this, 1 lakh 35,000.
Lordship,
loss nahi hai.
this table will show from whom how much has been recovered. But I want to bring that on
What
record,
was the
Lordship.
mechanism for that, sir?
I will bring this
That
table
was
to
not
record,
before the
Lordship.
Tribunal.
I will bring this table to record, Lordship. Lordship, we can go through this, Lordship, chart, Lordship.
The money from the other persons have already.
Yes, Lordship, we have already recovered. This chart will show, Lordship.
And only this person is left.
Lordship.
Khatam karo.
20 lakhs we have recovered, Lordship, including this petitioner. Respondent, Lordship.
Iska bhi nahi liya.
Annexure will show, Lordship. The annexure, last 2 pages. Last 2 pages. Nature of penalty and then remark.
Actual
The person,
maybe
he may be one of them. From one, we have recovered 7 lakhs. From one person, we have recovered 7 lakhs.
Yes.
Number 1 is Sabitri Burman Rai. From her, we have recovered, Lordship, 7 lakhs. Then Deepak Goswami, we have on appeal, he got relief. Then Kankana Das.
Appeal, he got relief without any modification of the imposed. No, on appeal, the appellate authority disposed of without any modification in the penalty.
Lordship, sorry, Lordship, without modification. Then Kankana Das, penalty of 7,81,000. 2 rupees, it was reduced to 6 lakhs, Lordship. Then Diksha Patoa, on review, recovery of 87,000. Then Niharendu Dev, Lordship, recovery is 80,000. Then Bharati Chaudhary, Lordship, amount is 1 lakh.
What is the mechanism to calculate this? What was the mechanism? Iska itna liability hai, this person is liable for so and so.
Let me take instruction to that, Lordship.
What is the instruction, sir? You have to set.
Because all these facts were not pleaded in the before the settled administrative tribunal.
We
Lordship.
have not taken that, then we are not supposed to now consider it.
Lordship,
That was not your this stand before the. How can we now go into all?
The tribunal held that he was not a party to that. There was no allegation that he was a party to the fraud. Our charge was not he is a party to. Our charge was dereliction of duty and lack of devotion. That is apparent, Lordship.
When he was posted, these whatever the backlog was of 7 months was already pending, and he asked for the support.
But he himself admit, Lordship, had it been properly, he would have checked that this fraud would not have occurred. That is stated in his reply, Lordship. He admit that, Lordship.
Who is appearing for the other side?
D.N. Sharma, Mr. He on last occasion also he was not here.
The day. Come from the next day prepared.
Lordship.
Going to. Yes.
Passover matter 12.
Have you informed them?
Yes, Lordship, I have informed Mr. Dekar, Lordship. Their names are not reflected, therefore they missed it out.
What's the name by the?
Lordship,
Whose name is to be reflected?
Mr. Sanjeev Dekar, S. Dekar.
Okay, this with appeal. after a week while reflecting the name of Mr. S. Dika for, and to learned advocate for KVTA.
Lordship, well informed.
Supplementary list, item 31.
After a week.
Please,
Your
Lord.
Lordship, I am for
Let's
the
read-
appellant. I have been led by my senior who has joined VC through VC.
Let's, I beg to appear through VC. Let's may permit me to appear. But it's a matter wherein the impugn order Lord, stays the encashment of the bank guarantee.
First of April, first of the April is the date for final disposal.
But the order, if your lordships will see, is my lords now even the maintainability is in question. I appreciate your lordships. First week of April, the matter is fixed for final disposal, etc. But my lords, the interim order, my lords, is passed after 2 months of the invocation of the bank guarantee. Just have a look at the interim order.
Ultimately, even if we issue this notice,
Please.
to the respondent, it will returnable, and then only we can interfere with the interim order. We can't interfere in the interim order ex parte.
I appreciate, my lord, but kindly see the facts of this case.
2025 is coming.
Lord, CS, my lords, the learned honorable single judge has said, and fix the matter in the first week of April 2025.
And the most 7th tak aa jayega.
That's correct, my lord. That's correct, my lords. But, my lords, I am being severely prejudiced. That is why I am bothering your lordships, my lord, with this writ appeal. The reason is, my lord, the bank, I appreciate what is falling from your lordships. That heavens will not fall if, my lords, if we wait till first week of April and if the matter is finally disposed of.
Yeah.
My lords, my hunch is, my lords, that if the matter is not finally disposed of for some reason or whatever, my lords, the issue here is, my lords, just give me 1 minute. The issue here is, my lord, there is a valid termination.
We'll do one thing, we'll fix this appeal in 2nd week of April. Let us see, if not decided, then we'll consider it.
Well, let's may consider issuing notice in the meanwhile because respondent number 1 and 2 are the only contesting.
Returnable 4 weeks. Check.
Well, let's may fix it in the 2nd week. Well, let's I'll serve Dasti.
Yeah, we have already issued the notices and made returnable 4 weeks, huh?
Well, let's may consider making returnable 2 weeks. Well, let's I'll serve Dasti to the respondent number 1 and 2. Others are performer respondents.
Okay, 3 weeks.
3 weeks.
This registered AD in the street.
Obliged, my lord.
Item 32.
Concern, well, let's, can it be a fixed date before lordships if I may seek so, my lord?
Please,
All right.
let the registry may fix the date.
Very well. Obliged.
Well, pursuant to
He
filing.
has joined already today.
Well, yes. Well, pursuant to filing of the writ petition, I have been told by my learned friend that he has postponed it for today. Tomorrow, the matter is anyways listed, my lord. His undertaking may be recorded and lordship will
He has
dispose.
joined.
No, my lord, he will be joining.
He will be joining.
From tomorrow. From tomorrow.
And return to Guwahati on 19th of
19th
March.
from tomorrow.
Go and approach it.
But tomorrow the matter is already fixed. I've been told by my learned friend that he has postponed after filing the writ petition. It was supposed to happen today. He has postponed it for today, my lord. Matter is listed tomorrow. So lordship may record his undertaking and dispose it.
Why should they record this undertaking? What is this undertaking is?
My lord, because I'll just explain, my lord.
What is his undertaking is?
That today he won't take any coercive action, my lord.
They have already made this undertaking before the tribunal itself.
Yes.
They are not.
Yes, my lord.
Learned counsel for the respondent banquet has submitted that they are not going to take any coercive steps.
Yes.
Against the applicant till date of filing objection by.
Objection has been filed yesterday, my lord.
Yesterday, okay. Now, if the matter is not listed, how can they take?
No, my lord.
objection?
That's what my lord. Objection has been filed.
Don't. Only attempt is that some order from the High Court. So now we'll take care of that.
No, my lord. The matter is already
nothing is
already listed tomorrow, my lord.
listed. Then ठीक है. But
Matter is already listed tomorrow. They were
otherwise, we are going to pass some order then on merits.
yesterday.
Practice of approaching the High Court without there being any valid reason, we can't appreciate.
I'll withdraw his statement may be recorded.
Not at all. Not at all. If you are insisting, then we'll pass an order.
No, my lord, I'm not insisting.
Want to withdraw, dismiss as withdrawn.
Right.
Anybody is interested in hearing matter?
Item 26.
26, my lord.
We have received an affidavit.
I have filed an affidavit, Lordship. I have been,
That,
I have got an instruction, Lordship, that the respondent has expired. So
I'll make my
Scott has filed an affidavit, Lordship, that is taken with the record already.
Likhe, an affidavit is filed on behalf of this. It is informed to the court through an affidavit by the son of the respondent, Mr. Vagulal Prasad, that the respondent has expired on
18/12/2024.
2024, Lord.
12/2024.
10/12/2024.
And
10/12/2024.
10/12/2024
At Tinsukia, Lordship.
at Tinsukia.
Lordship, at his residence.
At this stage, Learned Counsel, residence and the room, we are not going to record all this. In that room and in residence, he died on so and so, expired on so and so, that's enough. The Learned Counsel, Mr. R. Majumdar, for the state, prays some time to move an appropriate application for bringing LRs of respondent on record. Time period for is granted, response for.
I'm obliged.
Yes.
Item 27.
In this case, we had filed an affidavit on 24th, 11, but unfortunately, inadvertently, it was not served on him, so served on the government council.
The standing council.
I'm giving today, Mr.
2 weeks, 3 weeks.
3 weeks, madam.
3 weeks.
Item 29.
Obliged.
No, it's okay. I'm out of service, Miller. I'm out of service. Adjournment gives me a chance to reformulate my arguments. It's okay. There's some other day, subject to he being there. Second week of April.
Second of April,
Second week of April.
Second week of.
But I shall try to persuade Miller.
It's your duty, you have taken fees for that. You have charged for that. To persuade us.